Amended. Representative O'Neill.
Yes, thank you, Mr. Speaker. A little while before we began this discussion of this bill, my wife texted me and asked, "What are you going to be doing?" And I was about to text back to her that we were going to be doing campaign finance reform. But I realized as I was about to hit the buttons that that simply wouldn't be true, because 8 years ago, we in fact did do campaign finance reform, as most people understand that to be. And so what we're doing tonight is the exact opposite. And she replied, well, that's what Wender must have been talking about when he was on the McEnroe show. He was surprised that the legislators were not screaming about it. Well, tonight, Mr. Speaker, we are screaming about it. This legislation that is before us undoes what was the signal achievement of the previous decade in terms of trying to change the campaign finance laws. I remember sitting in Governor Rell's office being persuaded by her to support the earliest version of this piece of legislation that we adopted in 2005 in her office, being persuaded that it was necessary to make these changes, even though I had objections and concerns and worries about where it might lead, because it was necessary to try to get the money out of the politics, to try to clean up the situation. And I voted for that very first version of this piece of legislation that we eventually adopted. Subsequent versions I had a harder time with. And the main reason why I had a really hard time voting for the version that finally passed and became law was that it contained a provision that I thought would always be a source of mischief. And that was the provision for the leadership PACs. That was the provision that dealt with things like the state central committees and the town committees and the roles that they were to play, but especially the leadership PACs. That left open a very big door for the kind of special interest money that we were supposed to be pushing out of our political process. We were supposed to have that under some kind of control. The leadership PACs and the other party committees were going to have a limited role to play in the campaigns of the future. They would still exist. They would give people an opportunity to have some kind of input, for the leaders to have some capacity to have some sort of influence and to help legislators who couldn't otherwise get support because they were new people, new candidates, had problems of one sort or another. They were some sort of a balance to the system of the public financing. And it was limited. That was supposed to be the saving grace of this leadership PAC, as opposed to what we had had before, when there were an almost unlimited number of political action committees controlled by legislators who would use that control to help with campaigns, and those committees which became a potential avenue for special interest money to work its way into the system. The bill before us tonight, as has been earlier said, eliminates the limitations on these types of political action committees and on the party committees. And what it does is it opens wide a huge door, a loophole that you can drive tractor trailers filled with money through and disperse that money into political campaigns at the same time that candidates are receiving the publicly funded program. Now, this is something which I think at its core undermines the essence of the political program, of the campaign finance reform program that was enacted 8 years ago. And because I think it is something that we should not do, I have an amendment. I hope the clerk has it as well. Thank you, Mr. Speaker. What this amendment does is that it strikes out Section 28 of what is now the underlying bill, renumbers the remaining sections, and internal references accordingly. And in so doing, it eliminates the change in the process for the leadership PACs and the party committees. It turns things back to the way they currently are under our existing law. If I may comment further. And I urge adoption.
Question before the chamber is adoption. of House Amendment B. Will you remark further, sir?
Thank you, Mr. Speaker. I would. During the course of the debate back in 2005, there was a discussion about this very subject of the role that the leadership PACs and the party committees were supposed to play. And the question was raised by then Representative Hamsey, asking what the role of the town committees and the state central committees and the leadership PACs by extension were to play. And the response of the proponent of the bill, the leader of the effort to change our finance laws, campaign finance laws, Representative Caruso, was, through you, Madam Speaker, a state party's role would be a percentage of the overall grant that would be provided to a candidate. For example, in a state representative race, the state party could provide 10% of the in-kind services to the individual running in that race. In-kind services would be described as voter file assistance, polling, some phone banking, and things of that sort. And the question was further made, is that the only role for the state parties? And the response was, through you, Madam Speaker, it was felt that it would be improper for a party such as the Democrat or Republican Party, the major parties, from giving financially to the candidates because, again, we wanted to keep this system tight. And political parties receive their money from individuals of special interest. And so in order to keep the special interest money out of the campaign directly, we felt the in-kind services or in-kind contributions would be the proper way to do that. But it was meant also to be a very limited role, 5 or 10% of what the donations made by the State Elections Enforcement Commission were going to give to the candidates. The system that we're talking about tonight is going to be a hybrid where unlimited amounts of money, virtually, are going to be spent by political committees to which special interest groups can and probably will contribute. It will be a vehicle for the reintroduction of the very special interest money that the public funding of campaigns was supposed to eliminate. And it was supposed to make our system clean and tight and a model for the rest of the country in terms of changing the process of how we finance our campaigns. The amendment before us restores the system, at least in its core concept, that we enacted in 2005. It prevents us from going backwards to the situation that existed before 2005 with the special interest money flowing into the system. Now, we could argue about what that role was and how significant it was and the fact that most people were not affected by it. But critically, special interest money could have an influence. And in light of everything that's been happening, I think we have to say that it's quite possible. It's not a theory. So, Mr. Speaker, I would urge the adoption of the amendment to restore the system, to preserve the system that we so proudly hailed when we adopted it 8 years ago. Thank you, Mr. Speaker.